Okay, how to ensure your company owns what you build. So at the founding, make sure that anything created by the founders of the company is assigned to the company. So that'll be done in actual company agreements and agreements signed by all founders of the company. Also include work done that's before the incorporation. So if the founder, one of the founders created something and then they're going to apply it as part of the company, make sure that the ownership is assigned into the actual company. Don't just say, okay, well, since we formed the company, all IP created after that date will belong to the company. You want to make sure that you backdate any prior IP. Employees, you want to make sure when you have people working for your company that they don't claim ownership of it. In a lot of cases, people will be working on things while they're at a company and they're using company time, company resources. You need to make sure that you have IP assignment agreements in place to make sure that whoever created it while they're on the clock, essentially for the company, they have the obligation to assign those ownership to the company itself. That can include inventions, software code, copyrighted material, IP created on the job. So using the resources on company time, you want to make sure that the company itself owns it. Independent contractors and agencies, simply because you pay someone to do something does not mean that you necessarily own it as the one who's paying the person. So it needs to be carefully written within the contract. Anything you create on behalf of this company will belong to the company. It doesn't belong to you individually. A written IP assignment will be required, and make sure that the person who creates it signs the assignment. It's a good practice to have both parties, both the assigner and the assignee, which would be a representative of the company, sign it. But at the bare minimum, you need to make sure that the person who creates the work assigns it over to the company. Common ownership mistakes. Oh, we hired somebody to write the software, to create the software app, or we hired someone, a manufacturer, to develop the product. So therefore, we own it. That is not necessarily true. In regards to software, let's say, code was written before the company existed. There can be a dispute who actually owns the rights to it. If you don't have particular paperwork with freelancers that you may hire online or independent contractors that work for your company, there could be a confusion as to who owned the rights to the IP. Consequences. These particular issues could potentially delay funding from investors. This is why it's really critical. Like, why people probably think, like, initially, why do I care about IP? Well, it can hurt raising money for your company, potentially devalue the company when you're trying to sell it. And it can also make licensing extremely difficult, because if you're going to license the rights to use particular IP to another individual, or like, let's say you develop software and then you want to license it to another company, or have subscribers pay for the rights to use the software, you need to make sure that it's clear that you actually protect the IP. Otherwise, somebody's going to be able to knock off the product without even infringing on the IP because you failed to protect it. So it's very critical in this stage to ensure another person's not going to be willing to pay for a license if they know they can obtain it for free elsewhere. So if they can find it on some sort of open source and it's similar to your software, why are they going to pay you a licensing fee? How to protect ideas early, make a decision early on. This is particular. I mean, not every company is going to have something that's patentable necessarily, but you'd be surprised if you create a physical product and it's unique in some way, like even if it's like something simple that you're selling on Amazon or Etsy, if it has some unique visual appearance to it, you could potentially get a design patent for it. It doesn't have to be like solve some amazing problem. It can really just be a device that looks substantially different than other devices, and it's like you're claiming it as your own, and you could potentially get a patent for it. Trade secrets, that would just be something you keep internal. You don't actually share it. You make sure that you have trade secret agreements within the company. You will not share this information. This will not become public. Use NDAs within the company and with collaborators who work with the company. Very critical to have non-disclosure agreements. Protect yourself under contract law. Really limit who sees sensitive details. Don't just share anything online, post about it. Don't include anything on the website that you don't want to be public knowledge. In regards to establishing a brand, that's when you're going to think about trademarks. So you're going to make sure you do conduct trademark searches, hire an attorney to do a trademark search, file trademark applications. That would be for like a brand name, logos. Those are both different types of trademarks. Patent applications. Again, not everything is patentable, but if you have an invention, you want to make sure that you file a patent application before the public disclosure. By public disclosure, I mean if you start selling a product online and you don't have a patent already filed, that would constitute a public disclosure. And at that point, it would create a 1-year bar. You would have to file a patent application within 1 year of making that public disclosure. Once a year elapses, and I've had clients like this in the past, they allow a year to pass. They'll be selling a product and then they'll be like, okay, oh, now I want to protect it. Now I want a patent for it. Well, it's too late. Once it's been out over a year, it's part of the public domain. And then that also constitutes a public disclosure. I'll give you some other examples. So let's say even if you share a picture of a product online, like on Instagram or any other social media, it could be considered a public disclosure. So be careful if you share any of your ideas online, because that could be used against you to prevent you from obtaining a patent. Okay, here's some common mistakes people come up with. So a lot of people want to get a brand name for something that's like, oh, okay, this is like describes our product. The problem with that is you can't get trademark over something that's descriptive. Like you can't say the best coffee. You couldn't get that because you're just describing coffee, like a product you're selling. So you have to be original. Like obviously Starbucks has a trademark because Starbucks, the name has nothing to do with the definition of coffee. Your brand name can be an asset or it can be considered a liability. Liability, I mean, is if you inadvertently infringe on someone else's brand name trademark, then it becomes a liability because then you can get sued for trademark infringement. So it's very important on the early stages. Okay, I want to come up with a brand. What brand do I want? Let me do a search. Let me make sure before I invest a lot of money into this particular brand and establishing brand recognition, make sure no one else already has the rights to it, because that can cost a lot of money. Like then you decide later on, okay, let's come up with a different brand name. Costs you a lot of time, a lot of money. You've already established customer trust for your brand as well. You're getting reviews, and then all of a sudden you need to change your brand. It potentially creates a problem down the line. All right. How to avoid costly rebrands. Trademark clearance search. I mentioned it earlier. Very critical to do this search. It's not terribly expensive in relation to the amount of value of your company. So you want to get a brand. Okay, these are some ideas. Like, okay, I really want to get this name. Well, maybe you have a couple of names in mind. Okay, let's search those. You can do a trademark clearance search, see what other trademarks may already exist that are similar. Just because your name is original doesn't mean you can even get a trademark. If it's substantially similar to another trademark that already exists, you can get rejected for a likelihood of confusion. And then you could potentially also, not only will you get rejected in the application phase, you could infringe if you're selling, making a profit using a name that's similar to someone else's. You could potentially face a lawsuit for trademark infringement. Avoid descriptive names, like I mentioned earlier, or generic names. File trademarks early for company name that you come up with, core product names. Also, use the marks consistently. I've had clients in the past that they actually put different types of brand names on their website. They'll use it with a couple of words in one place, and then they'll have like a single word here. they'll change the spelling around. Make sure you maintain consistency. If you have a word or a couple of words that you want as your brand name, make sure it's consistent when you're whatever site you're marketing it on, or whenever you have it on business cards. You want to make sure you have consistency for that brand name. Copyrights. Who really owns your code, content, and creative work? Copyrights, or what people think of like works of art, but it's also content creation, specific software code. Default rule may surprise people. The creator of a work of art or a creative work actually owns the rights to it unless rights are transferred to a company. So if you do not have those agreements in place at the time of conception, the person who created it will claim that they have the rights to it. So you hire a freelancer to develop a design, for example. Then they would say, oh, well, it's actually I own the copyright to it. So if you want to use this, you're going to have to pay me licensing fee. So that's why you want to make sure in the beginning it's clearly established in the agreement with the freelancer or the contractor. You do not own the rights to this individually. The rights to what you create for the company will be assigned to the company. This applies to software code, website content, creative designs, various marketing materials. This is a question that's more recent, like in the last couple of years. Who owns AI generated content? And everybody's using AI. If you're not using AI, then you're probably spending more time on things than you need to, because AI is making things more efficient. Of course, you need to make sure that you put in correct prompts. You need to fact check. You need to make sure that AI is not hallucinating new information. There's still a requirement for humans to oversee the process, but AI speeds up the process a lot. Short answer for who owns AI generated content. Purely AI generated content usually will have no copyright owner. US copyright law requires a human authorship, so AI itself cannot own a copyright. If AI creates content on its own, it's not protectable. That means anyone can be free to copy it. When ownership is stronger is if like humans provide some sort of creative direction, basically telling AI, okay, this is the project that I want. These are the parameters, and then you ask AI to create it based on those that input. Not just like, okay, AI, do this for me, not like a single line. That's most likely going to be a very generic prompt, and any of the AI output would not be protectable by yourself since AI generated it. If humans select, edit, rewrite AI output, so you take AI output and then you contribute by, okay, I'm going to make changes here, here, and there, and this is going to be my website. So AI maybe generate an image, and then you want to modify the image in some way. You can argue that it's an original work of art because those changes you made are different than the AI output. So it's potentially protectable under copyright law. AI is used as a tool, not the author. You need to make sure that your AI isn't doing all the work. It's just working for you. So make sure that while you're creating AI content, you keep track of like, this is what I input here. These are the changes that I made. So that if there's a dispute, like, do you actually own the copyright? You can establish, yes, I substantially contributed to the creation of this content. Okay, so here's an example, a couple of examples. One of them is potentially could be protected by copyright because a person contributed to it versus a generic prompt, which is AI only. Really, there's no chance of getting a copyright for this. So for the generic one, AI only, it's write a blog post about anxiety. A person says generate, like you just type in this one sentence and then you hit enter. It just really the human did nothing in it. The AI did all the work. So it's potentially not, you couldn't protect that under copyright law. Generic prompt, there's no particular human author, therefore you can't obtain copyright protection. Now, if you said, write a blog post for our mental health app, and then you say, I want this tone, this is the particular audience, include a particular story, end it with some practical application or tip. The human is contributing more to that AI generated content than the generic prompt. You can even make changes. So, like, let's say, okay, you take that blog output and then you revise it, come up with your own additions to it. You could argue, okay, well, this blog was the human contributed to it substantially, therefore it's protectable under copyright. Save your drafts, so make sure that you can go back and prove that, okay, yes, I contributed to creating this content. Okay, steps to protect your IP and social media platforms, Instagram, TikTok, YouTube, everything people are using for social media. It's the same process generally, but each platform has their own method of like how you protect it, so how you enforce your IP rights. Um, for example, like, okay, you want to copyright original content, videos, music, graphics, scripts. That's potentially all protectable under copyright. YouTube has like a content ID. TikTok, you can file IP complaints. Instagram has similar types of rights management. So make sure you're aware of, okay, if I have material that I think is, I believe to be original and protectable under IP law, make sure you take a look at what the policies are of the particular platform you're on. Document human involvement. Okay, so keep records of everything you've done. So let's say you take one video and then that you didn't create, like you could make changes to it, make your own additions to it. It could be considered an original creative work if you've substantially changed it. So that would mean like, okay, you may take something that was created by someone else, but then you put your own creative additions to it. It could be considered copyright protectable. Make sure you don't infringe on the other person's copyright. So like don't use like a full song and then claim that you own the rights to that song just because you put it in your video. Make sure that you have permission from other people who own IP rights if you're going to use that as part of your creation. Watermarking and brand, yeah, that's a good way to put a signature on it that establishes that it's yours. Make sure you put logos or watermarks on your works so that it's clearly identifiable as yours. Use contracts, NDAs, contributor agreements for collaborators. Mentioned that earlier. That's just very, very critical to document that. This is a table which kind of summarizes the different social media platforms and like what you can protect, how do you enforce it, best practices, just keep records, screenshots, copy over. Okay, this is the date I created this. This was the original. This is the revision. Just keep track and records of everything you're doing in terms of creating content. So that way you can go back and say, yes, I created this, and look at this other person. They're using it without my permission. If another channel is using your IP, you can report it and say, okay, they do not have my permission to post these videos. They do not have my permission to use my works of art or anything I created. Therefore, they need to be removed. Potentially, you could sue them for infringement. But the easiest way to remove them that's less costly than going all the way to litigation would be to just have them removed off of the social media platform. All right, so this pertains to, we talked about earlier, we're talking about digital content. This discussion is going to be about e-commerce and more of like physical products that you could be selling on different platforms. For example, Amazon, Walmart, Etsy. Each one of these companies, the major companies, does protect IP. You just need to make sure that you properly fill out the complaint forms. You need to be able to identify when someone is selling a copy or infringing on one of your products. IP protection matters a lot, especially like in Amazon branding. You don't want someone to tarnish your brand by selling a product that's less quality. Counterfeits and copycats are very common. Someone will see a popular product and they'll copy it, regardless if you have a patentable product and you came up with it. They'll just figure out a way to sell it for cheaper, and then you're losing market share as a result of that. In a lot of cases too, if you don't have brand registry on Amazon, people will sell products under your brand. Like let's say you create a page and they'll be selling products directly competing with you. But if you have Amazon brand protection, you can get those listings removed. And so it's very beneficial to file for a trademark and then apply for brand registry on places like Amazon and Walmart. Brand confusion really damages customer trust, because once someone is upset with a product, they're going to blame whatever the label is on the product. So if they're buying something and they say, okay, well, this brand is crap, and they're going to leave a negative review, and then you go back later and say, well, that's not even my product. Well, I mean, now you've got negative reviews, which can substantially impact how many people are going to buy your product in the future. This could have been avoided if you just made sure that third parties were not able to sell. Platforms may suspend listings or accounts if IP is challenged. Investors really do care about defensible, enforceable IP. They're going to be less inclined to invest in the company if they know some competitor can just copy it. So if some competitor can copy your brand or your products with no consequences, then they're going to be less likely to value your company. Steps for registering your products, or steps to protect your products. Make sure you register trademarks. You can apply early. One of the things you can do with trademarks is you can actually apply for a trademark before you even begin selling products or using the brand name. And so that's helpful to like establish it. Like, oh, well, I'm not selling any products necessarily under this brand yet. However, they call it an intent to use. So you intend to use the trademark in commerce at a later date. You could file a trademark based on future use. You can also, once you begin using a brand, you actually establish common law rights. So under the common law, you can protect your product. However, it's very beneficial to get federal trademark registration because it can protect you nationwide. Like let's say you just had a local business and then you only provided services like in a small area. They could argue someone else could come up with a similar name in another state, and they could say, well, they weren't even operating in our state. You can avoid that by applying for federal trademark registration. Once you get that granted, you can enforce it throughout the entire small another state can't copy your brand name. Enforcing rights, monitor listings. This is, services you can pay for like monitoring if you don't want to do it yourself. Monitoring listings for counterfeits, copycats, submit takedown requests or infringement reports, or have an attorney do it. Each one of these sites has different forms you can fill out. Document like your product development, meaning if you came up with an original product, make sure you have those CAD files or whatever initial files you have for this is my original design. Make sure you keep a record of those different prototypes you developed, and notes in regard to your invention. Maintain records of who created what aspect of the invention. Like you're going to obviously, in a lot of cases, not manufacture it in bulk yourself. Even if you come up with a prototype, you're going to hire a company in China or another company to like manufacture it for you. So make sure you have an agreement in place. Make sure you maintain records to ensure that it's clearly known that you own the IP for it. Use patents and copyrights where applicable. Patents like functional, unique designs. As I mentioned earlier, you could design patent for a lot of different products. People have products on Etsy and Amazon, Walmart, where they have design patents for it. And that can be very beneficial because once you have a design patent, or in some cases, a utility patent that protects the functionality of it, you can remove, not only would it have to be identical, but if it's similar, you can argue that their product infringes on your patent and you can get their listing removed, which is extremely beneficial because a lot of times it's a race to the bottom. If you don't have IP rights, you're just going to keep competing with other companies that are willing to go lower and lower in the price. Copyrights that can protect like unique types of packaging, even manuals, particular images that you come up with, anything that's like considered a creative work. Contracts with manufacturers, I mentioned earlier, you got to make sure that you include IP assignment, confidentiality clauses, because otherwise, a lot of times you may go to have something manufactured in China, and if you don't have an agreement in place, they're going to say, okay, well, why don't we just manufacture this product for somebody else too? There's no, what are you going to do? There's no, if you don't have an agreement in place, if you just say, hey, please manufacture this, they'll say, okay. But what's to prevent them from manufacturing your exact same product for someone else? That's more money for them. You need to make sure that you have these agreements in place before the manufacturer just decides, okay, I'm just going to, make it for a variety of different companies. Okay, so how to deal with IP trolls on platforms. IP trolling is a very common tactic because it eliminates competition. You target small sellers. You go after somebody who you think it's a bullying tactic. You have a company go and file a false complaint on a platform like, let's say, Amazon. I have a lot of experience with Amazon retailers, and that's why I keep referencing it. We would have trolls that would fill out a complaint form saying, hey, they're infringing on my patent. You need to have this listing removed. And then my client would get a notification from Amazon saying, your listing has been removed. You need to settle this with the other company. And then they contact an attorney, and it creates a big mess to try to get your listing back. Meanwhile, your listing may be off the platform for several weeks before you can get it put back on. And I can tell you a story. In one case, a company said that they had like over 100 patents for this particular company. And if you look at the patents closely, they're extremely narrow. They're not even that valuable of patents, but they do have registered patents. So they filled out a complaint form and said, "Hey, you're infringing." They told my client they're infringing on it. They got their product removed. And then I took a look at it and I'm like, okay, they're not infringing. I did like a claim chart. There's no way they're infringing on this. This patent is way too narrow. There's all these different features that they're not copying. There's no chance that you'd lose a case for patent infringement. So then I notified the person who filled out the complaint, the one who had over 100 patents. I was like, here, there's no way you're going to possibly win. You should, we demand that you remove this complaint and allow my client to keep selling. And they said no. And I'm like, okay, well then we're gonna sue you in court and we're gonna get a declaration of non-infringement. Thankfully, it didn't get to that point, but we had to go through a lot of back and forth to get my client's listing put back on. So first thing you want to do, in a lot of cases, it's helpful to hire an attorney just because you may not know. Like somebody may come with a demand letter, whether they generated, let's say they had an attorney do it, and it'll sound really professional. Like, okay, we own the rights to this. This is our patent number, 67245, and then they'll list some like patent number, or they'll saying you're infringing on our trademark, and then it has a registration number, and people will be scared, like, oh, okay, well, I better not get sued. This is like extremely dangerous for me, and they don't want to like necessarily hire an attorney. Really, really advise to get an attorney involved because the attorney can help you better assess the credibility of the complaint. Sometimes these complaints are kind of vague, overly broad, and a lot of times, like I said before, they'll target small sellers. They're trying to get quick settlements out of it. It's like an easy money scam. Make sure you don't panic. Assess the credibility of the complaint first. You can also respond through platform tools. Amazon has like brand registry, Project Zero, which protects against counterfeits, seller support. has their own brand portal as well. Make sure you submit evidence of originality, screenshots, photos, design history, claim charts. It'd be extremely difficult for a person to create who's not an attorney to do a claim chart. This is like a very, very particular field for patent attorneys. We do claim charts. We prove, okay, this is my client's product. This is the patent. And then you do a step-by-step analysis comparing the different elements of the patent versus all the elements of the product. And if there's one of the elements that my client's product does not have, then there's no infringement. All you really have to do is have one single difference between your product and then what the patent says. And if you have one single difference, you're not infringing. So it's very important to have an attorney assess that. And that was the case in Amazon. There were probably about I think there were like four different elements of this product. It had to do with like this attachment for a stationary bike. And there were like four different components of it that my client's product did not have that were in the patent. I'm like, okay, well, my client's product doesn't have this, or this. Here's four examples. And then the troll just said to me, okay, well, basically, sorry, not sorry. We'll see you in Amazon Apex. And I'm like, Amazon Apex, they actually have their own mini litigation. Amazon is so big that they almost have like their own mini court now. They've got an arbitration system. It's called a patent evaluation procedure, and you can go through there, and it's much faster than the courts. They went through. Each party spent $4,000, and then we won easily. I mean, of course, my client had to pay me attorney fees, so unfortunately, it wasn't a complete victory. But my client got their listing put back in. They had to pay attorney fees. However, they got their listing back. And in the future, that troll can no longer file a complaint for that particular product because it's been proven, okay, they don't actually own the rights to enforce against other products. Attempt direct communication. So I also recommend doing that with attorney help. I recommend not doing it on your own. Contact the complainant to refute, clarify, or negotiate. A lot of times trolls will just get scared when they see an attorney. Oh, an attorney's involved now. Oh, and they'll go back into hiding into their, where they live because they're just basically bullies. And so they'll go away. They'll drop the complaint if you can prove that their case is weak. Make sure you document everything. Keep emails, screenshots, timestamps. This is very important if issues escalate or repeat complaints occur. So sometimes they'll have like, oh, okay. I got the listing removed, or my client will come to me. I got my listing removed. Then I'll be like, I'll contact the person who complained, like, hey, this is an unfounded claim. You need to put this back on here, or we'll see you in court. And they'll withdraw their complaint. Then, like a year later, they'll file a complaint form again, get the listing removed for a few weeks. This can potentially make hundreds or thousands. It costs hundreds of thousands of dollars when you get your listing removed for a few weeks. It's very, very costly. So we want to avoid that. Legal support. So this is what I do as an IP attorney to trolls. I shine the light and then I turn them into stone. Just like if any of you are J.R.R. Tolkien fans, Lord of the Rings, yeah, trolls, when they see the light, they'll turn to stone. And so when I see these trolls who come out with like these complaints that are ridiculous, I just go through an assessment. I point out, through claim charts, if it's regards to a product and patent law, or if it's trademark, I'll do an assessment. You can also what's called get a declaration of non-infringement. So if you want to go all the way to the litigation phase, you can get a declaration of non-infringement, and at that point, you can even potentially get damages against the person who filed it. It may be difficult, of course, to collect those damages, but if you go through all the way to litigation and you can prove that it was a fraudulent claim, that can really deter these trolls from like ever filing claims in the future. All right, so early stage IP priority checklist. Do these first. Consult with an IP attorney. Assign all your intellectual property rights to the company. Make sure No contractor, employee, founder can claim that they own these individually. It all needs to be assigned to the company through an assignment agreement. Make sure you protect confidential ideas. That would be like trade secrets. As I mentioned earlier, trade secrets is like you don't publish this anywhere. You keep this entirely confidential in-house. To conduct trademark clearances searches, file for trademark applications, establish code and content ownership, making sure who owns it is clearly established. Consider if any novel products or services are patentable. The services, I mean, like, okay, if there's a novel type of software that you came up with, potentially you get a software patent. If there's a unique product, you can get a utility patent for that. Okay. Let me go open up, see if there's any questions here. Oh, I guess, if anyone has any questions, please email me or post it in the chat if you have any questions about IP. But I've worked with small companies, startups for like 10 years, and I could tell you that there's just, even if you think you don't have any IP and you don't need an IP attorney, you probably do. And so I highly recommend getting in contact with an IP attorney. If you own a company, or even if you're a content creator, even if you just sell, even if you have a side hustle where you sell products online and you want to get a brand name establishment for that, I recommend hiring an IP attorney. That concludes the webinar. Thank you so much for joining us.